The Illinois Workers' Compensation Act was created and is enforced in order to protect employees who are injured in the course of their employment. However, injuries that occur not exactly during the hours of employment may be covered as well. One example of those are injuries that occur in the parking lot of your place of employment. The Illinois courts have ruled that while you may technically not have punched in for the day, or technically may have punched out for the day, that parking lot injuries will be covered provided you can establish a few factors. First, one must establish that the time in which the injury occurred was in close proximity to the time that the individual would be working. In short, that the injury occurred a reasonable time before or a reasonable time after the employment took place. Second, the courts have asked whether or not the employer had some sort of direction or control over the lot where the injury occurred. It's not necessary to show that the employer owned the lot where the injury occurred, but merely that they had some interest in it, perhaps contributing to the maintenance, and perhaps directing specifically where an employee would park in such a lot. Third, the courts ask whether or not there was something about the parking lot that increased the risk of injury to the employee. Did the individual fall as a result of ice and snow? Did the individual trip in a pothole that was a defect in the pavement of the lot? While we know that injuries that occur within the place of employment after punching in and before punching out are covered, the injured worker should know that if injuries are sustained in that lot at a reasonable time before and after, a lot that has some direction or control exerted by the employer and comes as a result of a defect, ice, or a pothole, that injuries in employee parking lots are covered by the Illinois Workers' Compensation Act.